Today I'd like to go over what are the New York State DWI refusal warnings. Hi, my name is Larry Newman. I'm an attorney focusing on DWI defense and personal injury cases in upstate New York. Today I'd like to go over after the police place you under arrest for a DWI out on the street based upon their observations or their field side testing. That's called common law DWI. They're going to bring you back to the trooper barracks or the police station, and then they're going to ask you, request from you a sample of your breath to do what's called the chemical test. The chemical test is the big breath machine. That's the one that you're going to blow into, and that is an evidential breath machine, meaning that they can use that sample evidence to have a case against you for a DWI per se, or the DWI based upon a percentage of alcohol in your bloodstream, based on an indirect measurement of breath alcohol. So the warnings that they're going to have to give you, they usually read off a card, and they have to read them in a way that you're going to at least understand. I'm not reading them too fast, but I'm going to run through them. There's 4 parts to the DWI refusal warnings in New York State. Number 1 is, you are under arrest for driving while intoxicated. Well, they told you that on the street. They're just repeating that back at the station now. Because you've been arrested for a common law DWI, they can now make a lawful request for a sample of your body fluids. So this is not in violation of the 4th Amendment right to unreasonable search and seizure. They have a reason now based upon being arrested out on the street for a common law DWI. Second part to the refusal warnings. A refusal to submit to a chemical test or any portion thereof will result in an immediate suspension and subsequent revocation of your license or operating privilege, whether or not you're found guilty of the charge for which you are arrested. In other words, even if you're not found guilty of the DWI out on the street, this failure to do their test, their chemical test, will still result in a suspension of your driver's license or operating privilege, because if you're from another state, they can't touch your license, but they can touch your privilege to drive in New York. And revocation. The difference between a suspension and revocation. Revocation is cancellation of your license privilege. And that's for 1 year. So even if you're found not guilty of the original DWI charge, you're still going to face administrative ramifications, consequences from refusing their test. Part number 3 of the warning. Your refusal to submit to a chemical test or any portion thereof can be introduced into evidence against you at any trial, proceeding, or hearing resulting from this arrest. So, going back to the original DWI arrest, your refusal now to take this test can be used against you. In other words, they're entitled to ask for, and the judge is going to give them an instruction stating that because you didn't do this chemical test, that you have a consciousness of your own guilt. They're entitled to ask for that. They're entitled to get that. So that evidence, the evidence of your refusing to submit, can be used against you. 4th part to the refusal warning. Will you submit to a chemical test to determine the alcohol or drug content of your blood? Now, it's really an indirect measurement in just a breath test of your breath alcohol, and then they're going to extrapolate and tell you what your blood alcohol level was. But you have to understand that if you refuse, if you choose to not give them a sample at this time, that you're going to have these issues in terms of suspension and then revocation of your driving privileges or operating privileges to drive in New York State. If you have questions about your DWI case, feel free to call me or shoot me an email. I'd be more than happy to help you. And thanks for watching this video.